All right, welcome. This will officially start the first meeting of the interim for the subcommittee on legislator ethics complaint procedure. It looks like we're short a couple of members, but we'll go ahead and get started as the meeting is set. All right, welcome. This will officially start the first. Little rocky here doing a full Zoom live meeting. We'll work out the kinks. It's been a minute. With that, we'll start with roll call.
Representative Yin.
Here.
Representative Svanitzer.
Excused.
Senator Barlow.
Excused.
Senator Rothfuss.
Here.
Co-Chairman Stith.
Here.
And Chairman Nethercutt.
Here. All right, well, it's good to see you, committee members. We have some work ahead of us. As you know, we have been asked to come together to revise and improve our rule for 22-1, which is the ethics complaint procedure for legislators. In recent years, I think we've learned there's been some of these complaints, and as a result of that, a review of this policy has been carefully walked through, and some issues have been identified with it that we think we might be able to improve upon by making some clarifying amendments to the rule and make the process maybe smoother. I anticipate at the end of our committee work this interim that we will have successfully amended this rule, but the rule will stay likely in place. But certainly looking forward to hearing comments from the committee and the public concerning their thoughts and comments on the rule and how it has worked. So with that, I'll turn it over to LSO and Director Obrecht to provide us some history on the rule and further comments.
Thank you, Madam Chairman. So Joint Rule 22-1 is the ethics rule that first went into place in 2011. And it was in response to an ethics complaint filed against a member of the Wyoming House of Representatives at that time. And there was no formal process in House rules, Senate rules, or the joint rules on how to handle such a complaint. So leadership at the time in both bodies thought it was prudent to adopt a rule. Majority Floor Leader Tom Lubnow at the time was kind of the driving force behind the adoption of the rule. In the 12 years it's been in place, I think if you count that first, well, actually that first complaint wasn't handled under the rule. So I think there's been 10 individual incidents that have been adjudicated or handled under Joint Rule 22-1. I think I know I've been involved in all 10 of those. And I've got to see that, leadership had thoughts, ideas for improving that rule as they became more familiar with it, and as we tried to adapt it to different circumstances, different fact scenarios. And I think, the Senate took the step this year of even repealing the Joint Rule 22-1 as it applies to the Senate. So right now, as we stand, the rule is only in place for the House of Representatives and the Senate. If an ethics complaint is filed against a senator, it will be up to the presiding officer to decide, and then ultimately the whole body to decide how to handle that complaint. And Madam Chairman, do you want me to walk through the rule itself, or?
Director, I think we will. Questions from the committee at this point regarding the history of the rule? All right, seeing none, Director, go ahead and proceed.
Okay, I'm just pulling up the rule here. So, Madam Chairman and members of the subcommittee, Joint Rule 22-1 provides a means for any person to file a complaint against a legislator for misconduct involving legislative duties. And that's a defined term within the rule itself, within Joint Rule 22-1A1. Misconduct involving legislative duties is a violation of Article 3 of the Wyoming Constitution, the Ethics and Disclosure Act. And that statutory site for the Ethics Act is 93101 at SEC. Any of the Wyoming conflict of interest statutes, violence or disorderly conduct during legislative meetings, sessions, or during the performance of legislative duties, or bribes or offers of bribes. The subsection 1 of the rule further states that an investigation instituted for political purposes and not connected with intended legislation or any of the matters upon which a House should act is not a proper legislative proceeding and is beyond the authority of the House or the legislature. So at the start of the process, after a complaint is received, and I should probably say at this point in time, we have always determined that under subsection A of the rule that the complaint must be in writing and must have a wet signature on it. So email complaints aren't enough. We actually need a physical copy of the complaint per the rule. The presiding officer, after that person gets the complaint, may dismiss it, summarily dismiss it, after consultation with the majority and minority floor leaders. If on its face, the complaint appears to be frivolous or submitted for any improper purpose, notice of summary dismissal will be provided to the complainant. And Madam Chairman, every presiding officer that I've worked with on this has also read what we call a Rule 12b6 standard into that motion to dismiss as well. And that means that evaluating the facts as alleged in the complaint as true in the light most favorable to the complainant. If those facts fail to allege misconduct involving legislative duties, as that term is defined in the rule, then the presiding officer, after consultation with the majority and minority floor leaders, may dismiss the complaint as well. If the complaint is not dismissed at this stage, it is forwarded on to a subcommittee of management council from the House, in which the legislator whose conduct is complained of is a member. So for House members, it's all the representatives on management council. Senators, if they still have the rule, it would be the Senate members of management council. And then that subcommittee is tasked with determining whether there's probable cause to believe that legislative misconduct had occurred. If that subcommittee can take additional testimony, the person against who the complaint is filed has an opportunity to present evidence, either written, or if the committee so chooses, may appear before the committee. All of the proceedings of the committee are confidential. The whole complaint process through this time is confidential. If the committee makes a determination that there's probable cause to believe legislative misconduct has occurred, then they forward that to an investigative committee, again from the same House against as the member against who the complaint was filed. That investigative committee, for lack of a better word, holds a quasi-judicial proceeding, and members can be represented by counsel. They can present evidence. They can call witnesses, cross-examine witnesses, and then that special investigative committee ultimately makes a recommendation to the full body on whether legislative misconduct occurred, and if it did, what would be the appropriate course of action to handle that issue.
Madam Chairwoman, woman,
Yes,
I don't know if I heard Matt say this or not, but the special committee, all proceedings are open to the public.
thank you.
Not say that. That's true though.
Well, thank you for that overview of 22-1. We do know that no one knows the rule as well as you do. Committee members, any question about the rule right now for the director? All right, seeing none. And just for the committee's information and the public, no one did sign up for public comment prior to last night before 5 p.m. And so we don't have any anticipated public comment for this Zoom meeting. So just so you all know that there'll be no ability to take public comment for this meeting. So I won't be doing that. We'll just be working through the rule. And so with that, director, as a result of,
Madam Chairman,
yes,
I'm so sorry to interrupt, but that may have changed since we spoke earlier this morning. Let's check with our staff member, Mr. Chestnut.
wonderful.
We have 2 people that registered online this morning at 10:30 a.m. and 11 a.m. It's Margaret Herman and Wendy Volk.
Okay,
It'll be your discretion to either allow them to participate or.
let's go ahead and bring in whoever signed up first.
Yep.
And we'll hear from them. And then we'll go to the next public comment.
And Miss Herman should be online.
Thank you, and I appreciate the opportunity. And just for the record, I did sign up yesterday before 5 p.m. So I don't know, there must be some lag time in reporting there. Doesn't matter. I appreciate the opportunity. And I will just say the piece that is missing that you may or may not want to address in this joint rule is the accountability the legislature can take for members' behavior under color of their office outside the Capitol. And I'm thinking of an occasion during a school board meeting in Cheyenne where a member of the legislature wearing his legislative badge, et cetera, behavior was objectionable. It seemed to be or was potentially subject of a complaint. And so it was an elected official trying to disrupt a lawful conduct of a board for a state subdivision, which a school district is. So I don't know if you want to maybe it wasn't contemplated in 2011, is behavior on social media or just under color of office, not as a private citizen, but using legislative standing to, that behavior, is that accountable and accountable to whom? And you may decide that you don't want to tackle it, but I would just say, it's an issue, and certain members of the legislature, and I think actually in the Senate, there has been some notice taken of comments made as a legislator, and I make that distinction, that are offensive or somehow violate ethics. So it's not clear the sideboards on the kind of behavior conduct that comes under the purview of the Management Council and this rule. So that might be helpful. It's a different world than it was just 12 years ago.
You're muted, Senator.
Thank you, Ms. Herman. Forgive me if you did this. I don't recall it. Could you introduce yourself?
Oh, I'm sorry. Marguerite Herman, and I'm here for the League of Women Voters and longtime observer of the legislative process.
Thank you, Ms. Herman. We appreciate your comments here today. Any
Madam
questions,
Chairman.
Ms. Herman? Senator Rothfuss.
Thank you, Madam Chairman. Ms. Herman, you did hit upon a point which I think is a philosophically challenging one, that we do need to discuss, but I'm curious to hear your thoughts on it, which is saying that we should govern our own for their behavior in their official capacity kind of makes sense as a first point of discussion. But then as you start to think about, well, what is and isn't appropriate for us to govern of a duly elected official that's representing their constituents in the way that they see it best, where do we draw that line is an interesting question, and there is no clear answer. So I guess I'd be interested in hearing a little bit more about your thoughts as to what direction you would feel you would want us to go.
Thank you for the question, Chairman Nethercott. I understand the difficulty of defining what is someone using office improperly, or actions taken as a member of the legislature, and distinguishing from, as a parent or as a member of the community. And, I would say, I don't think it's difficult. It's not impossible. And I think it's important enough to try to make that distinction, define it somehow. So a legislator fairly has notice, I'm behaving a certain way. This is, people are going to take notice of this in the legislature versus I'm just held to some community standard of being a decent person. So I think for the benefit of the public and for the member of the legislature, it has to have some kind of a predictability. But and you may choose not to tackle it because it is hard, but I think that there is a standard of behavior. And when a person is representing the legislature, so it is, let's say you can establish clearly this person was speaking out or posting on social media, whatever, as an elected official person, member of the legislature. And that I think there should be some accountability called, and I don't know what the punishment, what that accountability looks like, but I think I think it reflects on the whole body. I think it reflects on the nature of the work that the legislature does for the benefit of the public. And so I think sort of for the benefit of the institution, there should be some accountability outside the Capitol. Someone going into a city council meeting and disrupting, but clearly under color of having been elected a member of the legislature. I think there should be some accountability. And I sort of leave it to you how you want to do that. I'm certainly happy to join any conversation. Have not been invited to, but I think you can do it, and I think it's worth doing.
All right.
Thank you. Thank you, Madam Chairman.
Thank you. Any further questions for Ms. Herman?
Madam Chairman.
Co-Chairman?
Madam Chairman, Ms. Herman, thank you for your comments. It is a kind of a thorny issue. Do you have an idea of what kind of rule that you would like to see? And using the example of a legislator who's appearing before another public body, say a school board, wearing his or her legislative badge, would you want the ethics requirements to include a prohibition on rude or offensive behavior, or would you want it limited to something like advocating violence or the violent overthrow of the government or some crime? I mean, and I ask that just because it seems that it could be difficult to make it workable if we're going to merely police whether someone's rude or offensive. I think that gets difficult to judge, but I'd appreciate your thoughts on what you would like the rule to be.
Ms. Herman?
Madam Chairman, no, I appreciate the question. I would say it's the same distinction you make for legislative behavior in a committee room, or many times committee members become rude and offensive. They are not dinged for that. I think they are rightly called out for behavior that does, I guess, and I know I'm getting fuzzy here, but I said, but whatever standard of behavior you have for work, say in a committee or on the floor and debate, you could apply that same standard. And I think the legislature is loath to, well, you didn't use the right fork at lunch. We're talking about things that are a breach of legislative procedure or and then of course getting out of the Capitol building, disruptive, contemptuous of law and order. I don't know how you'd want to put it, but I think definitely you don't want it to simply be somebody, you know, you found the behavior offensive. And I will just make a note, Madam Chairman, that the other person who is signed up to speak is a member of the public who has felt that behavior in a meeting and did not issue a complaint because it was kind of ambiguous standing the person had, and so she may be able to answer further questions on this. But I agree that I appreciate the distinction that this should be reserved for truly behavior that is outside simply, you know, our styles are different. I mean, it should be fairly serious breach, I think. I haven't really thought about exactly how the wording on that, but it is something, especially in these political times, which then Speaker Love now referenced exactly in his comments. You don't want this simply to be, I find him crude. No, I think it has to be more than that.
Madam Chairman.
Senator Ruffus.
Thank you, Madam Chairman. And it's going to be, I think, a struggle to get that language right. And I think about other states that have taken action against members in recent months where the votes ended up very much along party lines. So ethics became, do you agree with your party's viewpoints, yes or no? And I think that's something that we clearly want to avoid, an ethics rule where that can end up being the deciding factors. Do I agree with what was said more than do I agree with the behavior? And at the same time, there's a certain aspect of who are we, the other 30 senators, for example, to tell one senator what is and isn't right in how they represent their constituents in the public and what they choose to represent in drawing that line, where maybe there are some things that, as Representative Stith, Co-Chairman Stith said a few minutes ago, clearly criminal behavior, advocating for violence. There are some things that are clearly beyond reason. But we would look to you and anyone else that is interested in trying to improve this for something that looks more like a bright line that can help us to resolve these situations and understand with clarity instead of with individual viewpoints kind of coloring that outcome. Thank you, Madam Chairman. Thank you, Ms. Herman.
All right, I see Senator Barlow came back on. He is off and on because his internet is not as reliable as ours, and so he turns his camera off in order to preserve, I think, his energy associated with participating on the Zoom. But Senator Barlow, did you have a question for Ms. Herman? You're on mute.
Thank you, Madam Chairman. So I'm actually at Tribal Relations right now, so we're on our lunch break, and timing worked perfect. But they do not have that good of internet in this building, so I'm not. You can't even blame it on Northeast Wyoming today. So I guess my question and my thought is that there's a context to this that, first of all, we're talking about just etiquette. I mean, some of this is just flat out etiquette. And we don't have like an etiquette guide for legislators, right? There isn't I don't know who those famous people that teach you how to eat with your forks and your spoons and all that. There is no legislative etiquette. But I think some of that is what we're talking about. What we've been used to is how people treat each other. That's etiquette stuff. But when it goes to, I think what Ms. Herman is talking about, I wonder if there's the context, if you're using your legislative office for gain, political gain, in the context of some of these, whether it's another board meeting or something else, and leveraging your elected position in some way to trammel on other people's opinions or whatever, there might be a uniqueness in that comes because you are an elected official. And that, to me, that does rise above. That is a constitutional provision where you can't benefit from your office. And to me, this could be a benefit that somebody a public member might say, you know what, they think they're special because they're elected and they're using that in these other contexts. So it's kind of, I think about this in a lot of different senses, but I too have witnessed people of elected in elected capacities using their electedness, if you will, in contexts that really, I don't think they have, they're just Joe Q citizen when they're there. I don't know that they should have any special or anyway. So I throw that out there, maybe not to, I don't have an answer for it, but to me, it's just, it's an etiquette issue. But is there actually something more clear about, or could be more clear about, no, you're actually using your position in a way that's unacceptable. So thank you, Madam Chairman. And I'm going to turn my video off. Thank you.
Thank you, Senator. Ms. Herman, do you have any feedback?
Thank you, Madam Chairman. I appreciate the caution relayed by the subcommittee. But I do think, that the distinguishing feature is under color of office. So to try to intimidate and, walking into a meeting with the legislative badge on and waving a green book and making it point that I am an elected official and I think creates that color of office. And I think at that point, the legislature it does have a level of, I think, right and self-interest to weigh in on that kind of behavior. I don't know what kind of sanctions. Again, I don't think to unseat somebody or something like that. And I think, and I do trust the management council and the subcommittee first and the management council to distinguish whether this person just needs a little private talking to and, a little advice on how to comport themselves in public versus something that arises to a sanction. I trust the management council to make that, handle a complaint and do the right thing, and so that's where I would be very comfortable leaving it, but again, trying to make as bright a line as possible. And I think it's not easy, but I think it is important to do.
Ms. Herman, thank you. And thank you for being here with your comments. Certainly helped spur the debate that we've all actually been having in the legislature. I think all of the legislators have, as I think every legislature in every 50 states, all the 50 states have been trying to deal with as of late or understand more thoughtfully. I think all of us have felt or have received communications from the public asking us to do something about another one of our members. And that may or may not be appropriate or something that we can actually do. And so we have been having these discussions for a long time, but certainly for purposes of this committee meeting, you have helped us really bring some of these issues to light. We appreciate hearing from you. So with that, we'll go to our next member of the public, Ms. Volk. If you could turn your camera on.
Ms. Nethercott, I'd be happy to turn on my camera, but I'm at a hair salon getting my hair cut right now. So my name is Wendy Volk and I live in Laramie County, and I apologize as I'm not really in a place where I should be able to turn on a video camera. There's other people also getting their hair done. But I did want to take this opportunity to thank you for having a chance to speak. I did think long and hard about filing an ethics complaint against a Laramie County senator. On August 15th of 2021, I received notification from a friend of mine that this senator had gone on my social media platform and personally attacked me. And I am a licensed real estate professional. I'm a realtor. I am also a small business owner and a parent. And this particular senator was attacking me personally, questioning my status as a Republican for 40 years and saying, why hadn't the Republican Party done something to take me out sooner? And that he did this on at 8:30 on a Sunday morning. And unfortunately, 78 people that are his followers jumped on the bandwagon and also began attacking. And the very next day happened to be a school board meeting. And one of those, individuals that was weighing in on this social media thread had then personally threatened me and my family, had to file a police report. I received email threats. It was all related to this one simple post. I am not an elected official. I am active in the community in a number of capacities. But one of the things as a licensed realtor, to use the name and the trademark realtor, we have to follow a code of ethics. And we have a duty to the public, and there's very specific things about what our duty is to the public, what our duty is to fellow realtors, what is our duty on social media and things like that. So if you need a reference document, I'd be happy to share the National Board of Realtors Code of Ethics, because then you can be very specific about what specific item in the Code of Ethics is there a violation of. I did not feel comfortable filing an ethics complaint when I looked at what our current rules are, because there wasn't something where I could cite, here's exactly specific, the social media conduct. And this individual was a licensed, I mean, he's also a licensed realtor, and I could file an ethics complaint against him. But I also know that I might be throwing more gasoline onto that situation of where he can continue to attack my professionalism and my family and myself. So I chose not to respond by filing a complaint, but I do know that when Ms. Herman was mentioning about the school board meeting, a different legislator walking in with a sidearm, he was carrying a sidearm on his hip into a school board meeting on school property. Not what we want to see people necessarily walking into our schools, but as a licensed realtor, I am always wearing my realtor hat. There is no time I can take my realtor hat off. And so I don't think a legislator, even though you might not be in session, can you, I think when you're elected official, you're on 24/7. And I think also when I'm a licensed realtor, to hold my license, I have to continue to hold and conduct myself so that I am honorable to my profession and my fellow colleagues. It reflects poorly. All it takes is one bad apple, and it really denigrates our elected positions, our elected officials' positions. So I would concur with Ms. Herman, if there's a better way we can frame these ethics complaints and be able to cite something more specific, because I do think social media can immediately destroy someone's reputation in a very short time period. And that's not mentioned in our current rules. But I think if we can think clearly about, we need to treat one another with respect, but to have an elected official attack me on a Sunday morning and didn't have the courtesy, if he really disagreed with me, just pick up the phone and let's talk about it. But he, even in that attack online, he referenced about me coming to committee over many years, coming before the legislative body to testify in committees. And he even brought that up, saying, I mean, he's just challenging. It's like, is that really what we want to do with the public? Don't you want to have an active engagement, an open dialogue, and not threaten the public from not coming to speak before the body? So that's all I wanted to share with you. And I did sign up yesterday. So I appreciate this opportunity to speak with you, members of the committee.
Well, Ms. Volk, thank you. And I'm sorry to hear about what you experienced and how that has impacted your life as a citizen and as a member of the public who's come to testify in front of the legislature. I'm glad I agreed for you both to come in and testify, since it sounds like you signed up the night before. And so I'm glad we were able to hear from you and your participation in us developing and refining 22-1. Committee members, any questions for Ms. Volk? All right, seeing none, Ms. Volk, thank you. I hope your hair appointment goes well.
Thank you.
All right. Any other public comment? Have we heard from anyone else potentially?
We don't have anyone online, Madam Chairman.
All right, thank you. All right, committee, so you've heard some comments from the public. I anticipate those won't be the last for our interim work here on this topic. So any further discussion from the committee about those comments or thoughts? I know that is a challenge. So our rule right now has a limitation to it in addressing legislative behavior during session. And so there's kind of a gap that maybe the director can speak to, or other pieces about outside of session or outside of a day of session. And certainly the social media concern. As we've already identified, that's really difficult to address and to navigate. We are a part-time citizen legislature, and so we're not here to be an HR team all the time. These are elected officials that the people have duly elected to represent them, as opposed to some other type of employment situation. So it's a pretty hard balance to strike, I think, and certainly something I think all 50 states are grappling with at this point in time. Comments from the committee at this time before maybe I turn it over to the director to identify some of those technical portions of the rule that he has identified throughout the years that have resulted in some ambiguity or could use some cleanup. Senator Rothfuss?
Thanks, Madam Chairman. I just note that this has been one of the problems with 22-1 is that it seems to be structured to work reasonably well for a case where there is a clear violation of ethics law or constitutional obligation. For example, if somebody were to do something where they had a substantial personal individual gain, the process seems to have been structured appropriately for that. And I think that was actually what it was kind of built around 12 years ago, was that concept. In my experience over the time that I've been in the legislature and serving on management council for most of that time, the reality of the events that take place and the circumstances that take place are more similar to what Ms. Volk was talking about, where you have bad behavior or actions that reflect poorly on the institution, and you have a complaint that is not specifically a personal gain, but doesn't necessarily reflect well upon the legislature. And 22-1 doesn't really provide a process for that or contemplate it very well. And maybe it shouldn't, and maybe it should. And I think this is one of the hardest things for us to decide, is not where to draw the line for circumstances where there's a clear transgression of statute, but for circumstances where we don't collectively like a specific behavior very well, what do we do, and how far should we be able to go, and what's an appropriate process? So I think the testimony that we had is a wonderful start to lead us into the challenges that we face with putting together a better process for 22-1.
Committee, any further comments?
Madam Chairman, the suggestion that we expand the scope of legislative duties to anything under color of legislative authority, to me, would appear to would greatly broaden the rule and would effectively encompass anything that any of us do, because we're a citizen legislature. And so I think, to me, that would be overly broad, because the resources of management council to deal with misconduct involving direct legislative duties, that's one thing. But if we were tasked with acting as the Facebook police for monitoring the behavior of members on social media, I think that would lead to a proliferation of the ethics committee, and it would become a much larger, more full-time committee. Just to me, that and the benefit that we would gain, I think the costs of that might outweigh the benefits. And I can also see that leading to sort of satellite ethics complaints. That is, someone, a legislator attacks someone on social media, they attack back, and then or perhaps the legislator is initially attacked on social media and responds. It gets into a heated discussion, and then the legislator gets disciplined for, using, inappropriate language or otherwise being rude or offensive on social media. I think that's just, I don't know of a principled way to limit that we don't already have. To me, it just seems problematic to expand it to under color of legislative authority.
So committee members, I heard Ms. Herman bring up a concept that I'm curious to hear your thoughts about, which was a power imbalance. You know, is that something that should be considered here? You know, as a legislator, you're in a position of power, at least that may be the impression of the public or constituent. And so should that be a factor that we should be considering, or a distinguishing piece, Representative Stiff, Co-Chair Stiff, in regards to that exchange on social media, that there's a power imbalance?
Madam Chairman, I guess I'm just concerned that would really dramatically expand the scope of this ethics complaint procedure. I think the school board example is a really good one, because it happens a lot that legislators are in front of school boards just to explain what the legislator is doing. And conversations like that may get heated potentially. And I think to draw the distinction of whether the legislator wore their badge or not, I think that the basic relief is mostly at the polls. If you have a legislator who's engaging in that kind of outside of the legislature rude or offensive behavior, it seems to me the ballot box is where you remedy that. Otherwise, we become this kind of behavior police that I don't think that the legislature is well suited to, and I think it could easily be distorted by all sorts of other partisan considerations, because we don't want the ethics procedure to be used as a weapon to achieve other political goals.
And the rule contemplates that as well, right, Mr. Chairman? Senator Rothfuss?
Currently it does.
Thank you. Senator Rothfuss?
Yeah, Madam Chairman, and the rule contemplates it to some degree, but wasn't necessarily written in a way that was strong enough that couldn't allow for political gains, as long as you had the right membership, I guess, on the right Chamber's Management Council. But the concerns that I have are similar to Representative Stiff's, which is that the individual is an elected official as a representative or senator on behalf of the constituents that elected them, and they are entitled to speak in that capacity in a broad range of fora for good purpose. So the idea that there's effectively a power mismatch, if you're under good behavior and a representative shows up to a school board meeting and they choose to do that, and they say, well, I wanted to speak on behalf of my constituents that I support or oppose this position. Is that unreasonable? I mean, they are speaking as an elected official in that capacity. Candidly, it's not something I do. I kind of feel like it's a bit of a faux pas to show up in someone else's venue and try to meddle in their affairs. So I try and stay away from those types of circumstances personally. But it is just a personal choice. If somebody says, well, I feel like it's my obligation to show up to all the school board meetings and tell them what I think as a legislator, I don't know that I can say that's wrong. If they are acting...
Well, that's not wrong, Senator Rothfuss.
Yeah.
The rule is contemplating. So let's bring it back around to, I think, the concerns we heard about, which isn't legislators showing up at public meetings and expressing their views regarding the future of education in Wyoming. That's not the concerns presented before us, right? So,
what do you see as the line there, though, Senator?
Well, I think that's very difficult, right? Which is here, but just for purposes of us having a debate and making sure we're evaluating these issues, this is what we're trying to grapple with, right? So
Yeah.
I also heard the words bully and intimidate, so as factors. And then when you're in a position of perceived power and you bully or you attack or you chill free speech or people participating in public testimony, is that something we should consider? And so those are pieces, not necessarily a legislator communicating their opinion outside of the legislative session. I think it has to do more with the with the intimidation, harassment,
Mhm.
on it, which were the words we heard from those witnesses here today.
Yeah, agreed. Thanks.
All right, so with that, we will go to the director to identify those pieces of the rule that have historically served as maybe points of question or concern, and we'll walk through those to see if there's some solutions we can come up with.
Thank you, Chairman Nethercott. Appreciate it. And I think the first one is a bit to the point of Ms. Herman and Ms. Volk. And this would be a little bit unique for rules, but I think a lot of members of the public come to this rule process or this complaint process with expectations that leadership or management council has authority and power that it really doesn't to regulate the behavior of members. In fact, you know, in Wyoming, there's very little that leadership can actually do to discipline a member outside of session. Very little. You know, in other states, each member of the legislature gets a budget for staff and offices, and usually leadership can reduce that. That's one tool that they use. In the Wyoming legislature, you know, in the Senate president cannot remove a member from a committee even. And that was a choice that the Senate made. In the House, maybe that authority does exist and it has been exercised before. But I think one thing that could be considered are some legislative findings before the rule to help set reasonable expectations of what this complaint process will deliver, that members of the legislature are elected officials. And I think to co-chairman Stiff's point, that the real remedy a lot of the time resides in the ballot box. But that being said, and to Ms. Volk's point, even if a complaint doesn't arise to the level of legislative misconduct, that doesn't mean that leadership doesn't want to hear about these instances of legislators maybe not living up to the expectation that the body has for conduct of its members. And as a matter of fact, even if a complaint doesn't go through this process, that doesn't mean that the houses can't decide to act on and discipline a member potentially for that conduct during the session, or even take the extraordinary step of calling a special session to address it. So I think some legislative findings that helps delineate that, and also says, hey, no matter what this process is, the houses retain the authority to adopt whatever rules or policies necessary to maintain decorum and to hold the members of that body to the standards as expected by the members of that house. That would be a first suggestion, Chairman Nethercott.
Thank you, Director. I see Senator Barlow has a question for you on this topic. Senator Barlow.
Thank you. So I think one of the things that the director just hit on was the action. The action has to be taken by the entire body. And at this point, the director and I have had this conversation numerous times. Do we need to put it in the rule? A individual chamber can call itself into session for this purpose. I would speak to that. Thank you.
Madam Chairman, the acoustics were not good for me. Is it possible to have Senator Barlow repeat the substance of that comment?
Here's my understanding of what he said. Senator Barlow, maybe you can clarify if you're listening, is outside of the session, can the legislature call itself in to deal with the legislator's conduct outside of session? Because it requires a vote of the full house, the full chamber, either the Senate or the House, wherever that legislator resides. He says yes. So let's say, for example, there is a clear violation of law of a senator in July. So mid-session. Do we have to wait until we come back into session until the next January or February? Or can we call a special session for purposes of dealing with this issue? That's my understanding of this comment. You can give me a thumbs up. Director Obrecht, comments about that?
Yep, Madam Chairman, great question. And the legislature can call itself back into session to deal with that. The interesting aspect is under the Constitution, it takes a 2/3 vote of both houses to call yourself into special session. And one house by itself cannot call itself into special session without the other house. So we could, put some things into the rule that, would ask the other house to concur by at least by 2/3 vote in the finding of the first house that a special session is needed. But I don't think it would in any way be binding, but it would help guide the legislature in making that determination.
Madam Chairman, I may. So let's take a potential example of that. Let's imagine at the July Joint Appropriations Committee meeting, a legislator tells an agency department, I will vote in favor of increasing your budget by $10 million if you award a $1 million contract to my company that I own, something like that, something nice and egregious. Under our current rules, that would seem to be legislative duties, right? And it would seem to involve, it would come within the scope of the rule. It's just a procedurally, a complaint could be filed right away. The speaker could deal with it. The speaker could, or Senate president, as the case may be, could deal with that to determine whether it should go forward. Assume they do. I guess the only issue is you'd have to wait until January or February of session to actually have your so-called hearing or trial on that matter. Is that right? It's a matter of waiting 6 or 7 months to resolve the whole thing, right?
Director?
Chairman Nethercott and Chairman Stith, for final resolution, you're right. It would take until you're back in session. But I think one maybe potential distinction is you wouldn't have to wait to be in session to hold to summon an investigative committee, appoint that committee, and actually hold the hearings. You can do that outside of session. The rule contemplates that.
Senator Rothfuss?
Thank you, Madam Chairman. One thing that could be a potential addition to statute would be sort of some terms and conditions of a legislative session that's called for the purpose of addressing a complaint. So you could create a rule set for a session that was called for that purpose, whereby in those rules you made special exceptions that the other chamber would be recognized as present virtually for their opening. You could make something that basically said no action will be taken on any bills. You could basically narrow it and craft a rule set for that type of a special session such that nobody would be worried that the special session would take on other characteristics without a 2/3 rule change, which might be worth doing, putting in statute something along those lines if we're concerned enough about the possibility of needing to call a special session. Having that special session type pre-characterized in joint rule would potentially be a beneficial construct. And I'd look to Director Obrecht. I don't know if we've thought about that or talked about that before, but we designed special sessions in the past. I know we can do it. It would basically be characterizing a limited special session for one purpose.
Director?
Madam Chairman, Senator, yeah, I think that would be appropriate for rules or statute. Couple things maybe to point out. First is, per the Constitution, I don't think that the other house even needs to appear so long as whatever the house that's hearing the complaint gets their business wrapped up within 3 days. Also, you don't need the other house if the governor just calls you into session too. So the governor could always do that as well. So a petition from the presiding officer asking the governor to do that would circumvent the need for a 2/3 vote from either body to handle it. And remember, the legislature didn't even have the authority to call itself into session for the first 80 years or 85 years of statehood. I guess didn't need to.
Thank you, Director. All right, any further comments on this topic? All right, Director or Senator Rothfuss?
Madam Chairman, I guess one question for the director, as I know he's going to hit on a few things, is a delineation of things that can be done outside of session versus things that are requiring a session to do. And that's from, I mean, that you've got Constitution, you've got statute, and then you've got rules. We can obviously change the rules very easily as a part of this exercise. But I think it's important for us to understand that, as well as circumstances when we would need a majority of members, 2/3 of members, or individuals potentially like leadership or management council acting alone, what's within their power. I think it's good for us to understand those concepts, and I'll stop there, Madam Chairman.
All right, thank you, Senator. All right, Director, the floor is yours.
Great. And I think that, you know, maybe the low hanging fruit there to the senator's question, the thing that would take 2/3 vote, a super majority, is first to call yourself into session, if not already in session, and that would be 2/3 by both houses. And then removal of a member from the body takes 2/3 vote. Any other disciplinary action would just take a simple majority vote of the members of that house. And maybe it's good to bring up this point now while we're talking about this is the authority of a legislature to regulate its membership and to discipline its membership is quite broad. And I think we saw that on display in Tennessee earlier this summer, where there were active demonstrations by members on the floor, and those members were then expelled in short order from the Tennessee House, and then only to be reappointed again. But while that's true, that you've got broad authority, it's not unlimited. And maybe even in this session of the U.S. Supreme Court, in some ways has further restricted that authority. And the key thing is really a legislature cannot take disciplinary action against a member for the exercise of a constitutional right. And the paramount case on this involved the Georgia State House. In the late 1960s, there was a member elected who was a vocal opponent of the Vietnam War, even to go so far as to publicly pledge his support for the Viet Cong. And the Georgia House voted that he couldn't carry out his oath of office for his duties to the Constitution, and expelled him from the Georgia House. Case went to the U.S. Supreme Court. The Supreme Court said no, that member whose last name was Bond was exercising his First Amendment rights when he was protesting against the war, and therefore the Georgia House could not take disciplinary action against him based on exercise of those rights. And what is getting even more difficult for a legislature to navigate is the kind of speech that Ms. Volk talked about. Speech on social media where a member may make comments, and then his comments or that member's comments generate additional comments that become more violent potentially or more hateful, and can the body then somehow discipline that member for those initial comments. And I think that's an area that absolutely every legislative body is struggling with in this age of social media. So, Madam Chairman, I would say too that one thing that we've seen a lot recently is an uptick in complaints that were filed without firsthand knowledge of the event. Members either read about it in the news, or they saw action or some sort of behavior in a video stream of a legislative proceeding, either a session or a committee meeting, and they filed a complaint based on what they saw at that meeting that was public knowledge. There was no individualized harm or individualized knowledge of that complaint. And maybe the subcommittee would like to take that on. To actually file an ethics complaint, you have to have individualized knowledge or harm from a legislator. And I think it would be very important to differentiate between filing a complaint, but members of the public still have an avenue to complain. If they see behavior that they don't agree with or appreciate, they've got every avenue to address that through leadership, through all members of the legislature, and then at the ballot box ultimately, but it might not be appropriate for an ethics complaint.
Madam Chairman, on that point, I do think that would be an appropriate thing for us to include is, and this could be kind of a concept of standing for an ethics complaint through the process. As you note, anybody can bring anything to an individual legislator, and that legislator can represent them on the floor, and they can make whatever motion they want in session. But in terms of this formal process, that firsthand knowledge seems like a valuable aspect, and perhaps can be part of that summary judgment component, or could be more of an official. And this is something maybe we can talk through. There's two versions there where the presiding officers can make the decision of whether they have what we could call standing. It's not exactly standing, but or whether that would be something that through the process, the Legislative Service Office would kind of make the call on. This is not, as you do with it, it needs to be in paper and signed. You won't hand it over unless it is, but there is some judgment call on that one. So I guess I'd ask what the appropriate path for the determination of, is this affecting me firsthand? Do I have standing to submit an ethics complaint? Would that be something that we would want to see through the Legislative Service Office through your capacity as director, along with your team, or would that be something that we would think would go through to the presiding officers?
Senator, my thoughts on that would be the presiding officer. I mean, with consultation, obviously, with legal counsel from LSO, but I do think that determination needs to be made by the presiding officer. My thought, if anyone has a different concern about that, happy to hear. Co-Chairman Stitt?
Madam Chairman, I'm just trying to roll around in my head this requirement of either a quasi-standing requirement or a individualized, personalized knowledge requirement. Those are the two things I'm kind of struggling with. And to me, it seems for personalized knowledge, that's problematic, because if it's, say, disorderly conduct during a legislative committee hearing, for example, anyone who's watching that on YouTube does have personal knowledge to the extent that they saw it themselves. They saw the violent conduct by the member, for example. But I'm wondering if you could tighten it down and say, one suggestion might be to have a standing requirement. You either have to have been directly affected by this bad conduct, or you're a constituent. I mean, and I'm thinking, here's the example I'm thinking of. Let's imagine that you have a legislator during an interim committee meeting who pulls out a baseball bat and physically assaults the legislator that's sitting next to them, right? But let's imagine that all the legislators just think that's fair game, right? The legislators don't complain about it. They just think that's just another day at the legislature. A little horseplay among the legislators. It seems like someone who's a constituent can say, I really do care that my own representative or my own senator was engaging in this bad conduct. I mean, I don't know how else to narrow the standing requirement down to make it meaningful in an age where everything's on video already, open to and viewable by everybody in the whole world. Does any of that make sense?
Somewhat. I do think it does. I think it's important to recognize what the director indicated, which was it's not the only avenue for release, right? I mean, this process. So another legislator can make a motion on the floor, or the constituent can bring an issue to the leadership to then take private action against that legislator or have a conversation with that legislator. So it's not the only remedy available, but in order, recognizing the kind of heightened remedy that an ethics complaint does require that immediate and firsthand knowledge. I think I am partial to that, and I think that makes a lot of sense. Recognizing that, again, it's not the only remedy that someone who believes that they are aware of legislator misconduct and they want it addressed. I think it's still okay. In the event of Ms. Volk, right? I mean, she chose to not make an ethics complaint. She made that decision, and evidently no one else made that on her behalf. And she was the person in the best position to make that complaint.
Well, Madam Chairman, you'd agree, I think, that if someone, in the case where one legislator physically assaults another one during a committee meeting as part of their legislative duties, that you don't have to be the victim or even in the room to allege a complaint about that. It seems like certainly a constituent should be able to say, hey, I think that's, it's something that I saw that anyone who's watching it on video has personal knowledge of, right?
I don't. I'm going to see.
But the definition of personal knowledge is that something that you see happen. And if you see it happen in real time on YouTube, you are a witness to it, right?
Potentially, if you're watching it real time live on YouTube. But I do think, at what point is there a limitation? And so then we have to, at least in the alternative, put in, you must file a complaint within 72 hours. Otherwise, who will not have watched a YouTube video 10 years ago, right? We'll be having complaints forever. Politically motivated. Senator Rothfuss?
Yeah, Madam Chairman, that was actually what I was going to hit on, was the fact that the YouTube's recorded. So do I have to have watched it live, or can I watch a rerun of the YouTube a year later and then decide that I was aggrieved? And it's a challenging standard to allow I watched a YouTube to be in and of itself sufficient as a ground for this quasi standing we're talking about. I think that is overly broad, unless there were some special circumstance, which I guess gets back to your point, Senator Ellicott, that we would want some sort of a standing review process, which could be not just maybe the presiding officer, but presiding plus majority minority, something along those lines to contemplate it, as is the case with the frivolous standard that we have in 22-1.
All right, any further discussion on this topic? And committee members, I do intend to do a hard stop at 3, knowing that we are all doing a lot of committee meetings this time of year, and so don't want to overdo our time, and there'll be more of these meetings to the summer. So hard stop at 3. Director Obrecht, if you want to continue.
Thanks, Madam Chairman. The next potential to think about is, and I alluded to this earlier, but maybe incorporating that rules of civil procedure 12B6 standard, rule 12B6 standard into the motion to dismiss. That if the facts as alleged in the complaint, viewed in the light most favorable to the complainant, still fail to allege legislative misconduct as defined, then the complaint would be dismissed. I also think that the subcommittee may want to think about the confidentiality requirements in Rule 22-1 right now. Essentially, if a complaint's filed, the presiding officer, the subcommittee are bound to keep that complaint confidential. Really, the terms of the rule don't keep the complainant from releasing the complaint, or the member against who the complaint is filed from releasing that complaint. I think in this instance where, you know, we're really not talking about sensitive personnel issues here, sexual harassment or personnel issues. It's allegations of misconduct against a legislator, against an elected official, and maybe there is more room for these proceedings to happen in the public, and also for members of the public to know why the subcommittee or the presiding officer came to the ultimate conclusion on that complaint that they did. A lot of times in the past, the public's told that a complaint has been filed, and then they're told it's been dismissed, but there's never, or very rarely, is there a release of that letter, that document explaining why there was a finding of no probable cause, or a finding of why the complaint was dismissed.
Senator Rothfuss?
Thank you, Madam Chairman. So recalling back to when this was first discussed back in 2011, the purpose was not to give oxygen to false claims, right? So the intent was a good one, which was the idea that the ethics process could be abused with false claims just to get great news stories on frivolous claims. And so it was structured and written in a way to attempt to avoid giving any oxygen to those claims by having confidentiality by those that were considering the claim up to the point where it was considered a valid claim. Now I can say, again, with firsthand experience, that didn't work very well. I think the intent was a good one. I just don't think the process achieved what the intent was trying to achieve. There might have been some circumstances where there were fully frivolous claims that were dismissed and received no oxygen, but it tended to seem more fueled than by conspiracy than by information due to the confidentiality aspect. So I don't know if there is a better way for us to do that, where truly frivolous claims just don't get a lot of oxygen, but aren't necessarily at the level of confidential, or exactly how we can do that. I think the original intent was a good one. If there's a way we can capture and achieve that intent, I don't think we did it.
Further comments? Representative Yin, you're kind of quiet.
I am. I think I agree with my experience just in this last year being minority floor leader, that necessarily keeping it confidential doesn't actually mean that people don't get good news stories out of it. So yeah, I agree that it hasn't necessarily worked towards its intention, but I think it is a good intention. Trying to figure out what the right way to not let frivolous claims be used as weapons in that way, I think is difficult, but is worth thinking about for sure.
Tamara?
Madam Chairman, I can offer some suggestions from other states, although I know we don't want to get into the weeds here, but just quickly, that might work well for your purposes. One was to provide that all things are confidential until the complaint is handled, either dismissed, and at that time it all becomes open public record. The other was to say that all items are confidential unless released by the person filing the complaint. And if they release it, then the confidentiality provisions fall away.
Interesting. Comments from the committee? Senator Rothfuss?
Yeah, Madam Chairman, I don't know that either of those ends up being a perfect solution. There might be some merit to those concepts, but I as I reflect on things that we've done in the past or seen in the past, I should say, one of the challenges is it's almost like the only people that can't talk about it end up being those that are the leadership of the legislature that are contemplating it, and then honestly can like never talk about it. So any of these that I've been involved with in the past, except for one where the report was released, I still can't really talk about it, but everyone else does. Everyone else talks about it. Everyone else can talk about it. The complainant talks about it. The person that was complained about talks about it. It's all over the news. I can look at stories, but I still am held to confidentiality and I can't comment. Not that I necessarily should be commenting a lot on it. It's probably better that I don't on all of these things, but it has created an odd circumstance. And I don't know that what Ms. Rivoli has laid out fully resolves that odd circumstance.
Senator Barlow?
Thank you, Madam Chairman. That's what I was going to pick up on. I would get requests
Senator Barlow, we can't hear you.
to make
It's not
comment
clearly enough.
when
Put your
all
comments
the so.
in the chat. If you want to write your comments in the chat, I'll read them for you if you'd like. I don't see that he's typing, but Trevor, do you have anything else to add? Doesn't look like it. Can everybody hear me right now? All right, all right. Okay, with that, Senator Barlow indicated that Senator Rothfuss has covered it, so he concurs. Director Obrecht, do you want to continue?
You bet, Madam Chairman. I think the one other suggestion I would have is so if there's ever a probable cause determination that legislative misconduct occurred, the only avenue available to that subcommittee of management council is then to forward it onto this full-blown investigative committee with this quasi-judicial process. And that is likely to be the right avenue in a lot of the circumstances, but it may not be either. And to limit that group's ability to only do that really stymies leadership's and management council's ability to effectively manage situations within the legislative body. So that would be my suggestion, is to give that group the ability to retain jurisdiction, if you will, over the complaint, and recommend to the presiding officer different methods in which to address that complaint.
All right, thank you, Director. Any questions about that? Representative Stead?
Yeah, Madam Chairman, Director Obrecht. So I like that a lot. Would you propose leaving that very generalized, that they could just recommend other remedies and they can fashion it on a case-by-case basis? Or do you envision spelling out what in the rule what those other remedies might be?
Director?
Madam Chairman, Co-Chairman Stith, I think I would want to leave it open-ended, but we could certainly include a non-exhaustive list of potential ability to, potential avenues or tools that could be utilized to address the complaint at that stage.
Senator Barlow commented that the investigative committee needs to be able to retain confidentiality status. Co-Chairman Stitt.
Oh, Madam Chairman, no, I just back on the confidentiality, which was a different topic. I kind of like Director Obrecht's comments that maybe we just delete the confidentiality, and that might lead to more transparent, process without, it would be an improvement at least upon our current system. So, and Madam Chairman, just from a process point of view, I assume that our goal here within the next 34 minutes at least is to sort of have a laundry list of these suggestions that we broadly approve of, and that we'd ask for some kind of draft revised rule.
That's right.
Is that the idea?
That's what we'll do. That's what we're doing. Yep. Senator Rothfuss.
Thanks, Madam Chairman. On the confidentiality, I don't think we want to say it is or isn't confidential. I think we want to have circumstance determine the confidentiality for the investigative committee, and what level of confidentiality, probably starting, as Tamara said, with starting from confidentiality and then making rational choices about whether it should or shouldn't. The challenge might be what the process is for making those rational choices about what should and shouldn't be. But one thing that we've found in my experience is that it would be nice to have a letter at the end, so to speak, where a finding of some sort was made, but that's going to defy the confidentiality. So there needs to be some sort of a thoughtfulness process along what is and isn't confidential and who can disclose what. If both parties release, or actually right now it's unilateral, I guess, if one party releases, that's fine, they can release, but it still doesn't take away the confidentiality requirement of the investigative committee based on what is released, technically. Although I think when we released that letter from One Action a number of years ago, I think we may have just deemed that the information was released and can be talked about. I guess I'd ask Director Obrecht that. I'm a little unclear if we're released once the parties release it or not. How did we decide on that?
Director.
Madam Chairman, Senator. So in the instance you're referring to is ethics complaint that was filed against Senator Eli Bebout, and Senator Bebout waived his confidentiality, and that was actually included within that decision letter,
Right.
That the management council. So that one, we actually, if we ever get around to doing this, we'll post it on our website, or maybe it already is, in our ethics database, a decision letter, because the senator who held that privilege waived it. And also the complainants made that complaint public in that case right off the bat. So both sides had effectively waived their confidentiality. Now there's other instances where a complaint has been, and a decision letter has been published in a news source or media, and yet I don't feel like there's a waiver, a knowing waiver, at least maybe by all parties. And so we have, within staff and within the decision makers on that instance, we have treated those still as confidential.
Yeah, Madam Chairman and Director, that instance is a good example where that decision letter would have been a very reasonable public release, but we weren't entitled to release it publicly, but then it was released publicly by other parties. So it's an awkward circumstance where it ended up probably getting to where it needed to get to, but we couldn't affect that change. So that gets to the nature of that confidentiality rule is currently overly binding, but I do think there's merit to having an initial status of confidentiality, and then working from there based on some process to, I'll say, declassify information. But I don't know exactly what that is. There's complexity to that.
Senator Barlow wrote that there wasn't a rule before 2012. Do we really need one now? Should we discontinue what we have? I think that's a fair concern. I personally lean towards having some type of confidentiality provision in place. Those are my thoughts. Anyone else?
Madam Chairman,
Go,
on
Chairman.
I think confidentiality is kind of a thorny topic, but would it be rational to draw a distinction between the complaints that do not survive our Rule 12b-6 new process and those that do? That is, if I was advocating a moment ago for having no confidentiality, but then it occurred to me that that would mean that every frivolous complaint would just get posted on Facebook, and that might be problematic. Whereas perhaps if you've got a complaint that does survive and is serious, then maybe the need for confidentiality is lower. I don't know. It's
I do think that there is merit in having some type of confidentiality provision, even if the accused is exonerated, for lack of better terms. I think even those allegations, depending on what they are, can be pretty damaging. And of course, the complainant can do what they want, right? Particularly in the age of social media. But for our purposes and what we can control or maintain and to create a fair process, I do think there's some wisdom, at least at this point, in keeping some type of semblance of confidentiality associated with it. Otherwise, I do think it becomes quite a free-for-all.
well, Madam Chairman, if I may, I mean, the general public, including all of us, when it comes to the criminal law, there's no real confidentiality about that. If you get arrested and taken to jail, your picture is on jail tracker right away. And even though you're presumed innocent, a lot of damage is done to your reputation.
That's not true.
I think not true that there's damage to your reputation if you're falsely arrested for DUI. I think there would be.
Well, DUI is an example where yes, but for sexual assault, the defendant's name cannot be published or made public until after they've been arraigned. So there are even protections within the criminal code, depending on the type of charge, recognizing the unique stigma associated with some of those.
But Madam Chairman, I think that proves the point, because the Rule 22.1 is dealing with cases that don't involve allegations of sexual harassment, right?
I don't know. And I don't think we do know necessarily what all it would encompass. Senator Rothfuss, I see you moving closer to your mic.
Thanks, Madam Chairman. Yeah, I was going to say we can't suppose what is submitted as a 22-1 ethics complaint until it's submitted. So some level of discretion might be good, and it does make perfect sense to, in my view, to keep confidential those complaints deemed frivolous. That will take away some of the political motivation of just spamming complaints at somebody to draw attention to it. But there may be complaint categories that we're not anticipating that would benefit from confidentiality to protect the individual that's filing the complaint or some aspect of the complaint that might be sensitive. No good examples are coming to mind at this point in time, but just because of that doesn't mean there aren't good examples out there that could come to mind. So some flexibility might be of benefit. I don't know exactly how we can write that. Again, you've got an investigative team. So the frivolous aspect of it is currently presiding officer plus 2 leaders. And then I believe at that point, if it's deemed not frivolous, it goes to the investigative committee, which is the chamber's management council group would then be privy to those facts, and maybe they could have some discretion on what should and shouldn't be confidential unless otherwise released by one of the parties. And again, I'm just kind of thinking out loud on that, but providing for some discretion by that group might be an appropriate approach, although maybe there are some things that, and maybe final findings, which I believe was what Ms. Rivley suggested, other states have done, might always be public. I don't know if there's any, it's hard to thread the needle on this one.
It is a tough needle to thread. I think we don't disregard it because we can't find a solution. But I think we can move on, recognizing, I mean, it'll be my preference to keep a confidentiality provision in at this point upon further public comment and review. Director, is there anything additional you have that you'd like to go through?
Yeah, Madam Chairman, the only other thing is, and I don't have any suggestions for the subcommittee, so I apologize for that, but you know, the definition of misconduct involving legislative duties is by no means perfect or all-inclusive, or could include any circumstance where a legislator may, you know, require disciplinary action. So I don't know if the subcommittee, you know, we've looked at what other states do. Tamara can give you a better understanding of that general overview of what the categories are that other states do. They're all over the map. There's no consistency among the 50 states on what their definition for an actionable complaint is against a legislator. But so that's it. You know, we're here to provide any information we can about that, but we don't really have any recommendations.
Director, thank you. And just kind of on that piece and responding to that topic, that was a comment made by one of the commenters about, I think it was Ms. Wilk, who's a realtor, and her ethics hat associated with being a realtor is on all the time. And in my day job, I have advised other individuals who have fiduciary duties in different capacities that same advice, that responsibility is always with them, whether or not they're currently acting in that role or not. They always have to act in the best interest of that fiduciary relationship that they have. But that doesn't necessarily apply in the case of legislators. And so it's a unique construct. And so to tie our behavior or misconduct associated with us when we're wearing the hat, or does the hat come off? I don't have a clear answer to that because of the uniqueness of a legislative body and legislators. So I'll just leave that there and go to co-chairman for his comments.
Madam Chairman, I just had a clarifying question for Director Obrecht. It seems that right now, Rule 22(1)A Romanet 1 does define misconduct pretty tightly, actually. You know, it enumerates, it says it is defined as, and then it has a laundry list of things. Are you suggesting that we should broaden that definition of misconduct?
Co-chairman Steph, do you think disorderly conduct or doing the performance of their legislative duties is tight enough?
Madam Chairman, I mean, I think it's relatively understandable. I think that, you know, we have that exists in the criminal law already, right? That, you know, you can if you engage in disorderly conduct, that you can be cited for that, right? And of course, that takes on infinite variations. I mean, you are correct to suggest that that's probably the broadest of those terms. I mean,
I guess the other term is, what are our legislative duties? Is it communicating with my constituents? Is that a duty that I have? I don't know if that's a duty. versus something I should do as an elected official, but I'm not sure it's a legislatively or statutorily defined action that I take. So what are our legislative duties?
Madam Chairman, my first impression is that merely when you communicate with your constituents, that's not within the scope of legislative duties, because it's not something that it's something that you actually do. That's a good idea to do, but that's not something that the law requires you to do.
So where is legislative duties defined, Mr. Chairman?
Madam Chairman, I would think that in all of our joint rules where it says that we'll gavel in on this date, that we will show up, that we will vote, that we will, when we're assigned committee duties, to me, it seems like it's pretty tightly defined to committee responsibilities and session responsibilities, I would think. I mean, but if we wanted to tighten that up and say what exactly legislative duties means, that was I think the members of the public, our two commenters seem to, for very good reason, also wants to expand that to include a whole lot of other conduct that doesn't take place in a committee meeting or in the Capitol. But again, my view is that that's, would be difficult to constrain.
No, I don't disagree with you, Co-Chairman, and I think this is kind of part of our exercise, is either to provide clarity to the public about what we can and cannot do in order to reduce their frustration with us, and to feel like there is or isn't a process, and then further clarity for ourselves as what to be considered disorderly conduct in the performance of my legislative duties. There is always a pro and a con to having ambiguous terms as opposed to very prescriptive terms. So that's really the question before us in this scope. Senator Rothfuss?
Thanks, Madam Chairman. This language to me seems overly limiting in achieving like necessary flexibility. And I say that with one circumstance that I experienced where honestly, I wasn't particularly happy with an action that was taken that we saw through this process. And I felt like it would have been nice to write a letter or say something, which was basically, yeah, you didn't break the law, but this was not a good choice. Don't do that again. Kind of conclusion. But that's not really an option for something that isn't deemed, which again is a challenge to make the determination. Violence or disorderly conduct during legislative meetings. Again, what is that? That's pretty strong terms. And then you've got bribes or offers of bribes. So there are a lot of things you can do that look really bad and make the legislature look bad, and that are generally inappropriate behavior that don't fall into these categories, that might be worth at least a letter where you can write, hey, we don't appreciate this. This makes the legislature look bad. Don't do it again. Now, I'm not saying that rises necessarily to the level of, and therefore we're going to kick you out of the legislature, right? There's a lot of different levels of what should lead to what. But I would certainly support much broader discretion on what is and isn't, or what is within the purview of an ethics complaint based on if you're acting in your capacity as a legislature, that's different from performance of legislative duties, for example, right? I mean, if I've got my name tag on, I might not be performing a legislative duty, but I'm a legislator. And I mean, in my philosophy, I'm always a legislator, but not everybody believes that. And I don't think we have to force everyone to believe that. So it's not necessarily our role to do that. But I do believe that if I am acting in my capacity as a legislator and I do something that makes the legislature look bad, it is reasonably in bounds for the rest of the legislature to contemplate that as an action that I've taken. So broader language there, maybe looking to what other states have done. And that might get into social media. You know, is this page, am I posting something on a private personal page to 5 friends in my capacity as their 5 friends? Or do I put something on social media in my official capacity on a legislator page or as the page that I use as a legislator? I think those are different considerations as well. And again, maybe other legislatures have done a better job of coming up with the definition that we should use for that Romanet 1. But I do think that we should collectively have broader purview to make comment on, even if it's not rising to expulsion. But there's no reason an angry letter can't be written to indicate that whoever we, the undersigned, are don't appreciate it.
Director O'Brien?
Yeah, Madam Chairman. Yeah, I agree. That's certainly an option that's open to the members. I think that kind of, for me, dovetails back into the confidentiality question as well. If you get a complaint, and maybe it's not actionable completely or doesn't require any other disciplinary action, but a strongly worded letter is appropriate. You know, leadership maybe should have that ability to either decide whether that letter should be confidential or if it would serve the public purpose and the purpose of the Wyoming legislature to make that public.
All right, any further comments? Committee, I'm thinking for purposes of ease and understanding and the public's participation is that we ask LSO to do a rule draft with those proposed issues identified and maybe some proposed language by LSO addressing those concerns, or at least flagging them for us to come back to with some options. Senator Rothfuss?
Yeah, Madam Chairman, I think that's an excellent approach, really rewriting 22.1 with the context of all of these, all of this discussion, maybe providing some options. One thing, smaller issues, but things that I think need to be incorporated that haven't been incorporated. One is some appropriate process of recusal or exclusion where a member of the management council on the appropriate chamber side is involved. And there's a little tiny bit of language where if the presiding officer is involved, we know what to do, but in no other circumstance do we know what to do if there's a conflict. So conflict language to make sure that you've got a sufficient quorum or know what we're doing in the event that a member of the leadership or management council is an involved party. I think that should be thought through and added. There's lots of different ways to do it, just any appropriate way that ensures that you're not conflicted is one concept. And the other that I've struggled with, which is a policy decision, the fact that decisions are made by the presiding officer alone, even though it's with consultation, it doesn't have to be with agreement of anyone else. So you can have the presiding officer ask the 2 leaders, and both of the leaders, for example, let's say they say, yeah, this is a bad deal, we need to investigate that. And then the leader says, all right, well, I'm glad that I talked to you both. It is dismissed. Now, I do realize there's remedy there. So maybe it's not essential that we restructure that in any way. The remedy being, as an individual member, I can always bring whatever I want. And as leader, I probably know that. So maybe it's fine. But that was a concern that I remember having 13 years ago, 12 years ago when we worked this the first time. And it remains a concern. There's probably a better way. It seems to me almost that to dismiss something, all 3 of those members non-conflicted should agree that it needs to be dismissed.
Co-chairman?
Madam Chairman, doesn't that create a problem if you don't have unanimous agreement, then you can't dismiss a complaint? I mean, that gives a veto power over someone who wants to pursue an otherwise frivolous complaint because it's good political theater for them. I mean, I don't mind our current system of allowing the presiding officer to make the call. I do appreciate the conflict of interest point you make. And if I may, if I understood what the chairman said a moment ago, we're requesting a rule draft changes that would include one, a proposed preamble talking about sort of what to expect when you're complaining. Rule 12b6 standard motion to dismiss. If the investigative committee finds a probable cause does exist, then the committee can have other remedies, not just the current ones listed. And then I don't know if we have reached consensus on how confidentiality is to be handled. But
I think my direction was just to leave it as a flag, continue to open for consideration at our next meeting, and I have the director go through what he understands the task item would be here right now. Co-chairman, if you need to get off to get to your next meeting, understand completely. We're pushing up against a 3 o'clock. Senator Rothfuss?
Yeah, Madam Chairman, to respond to Co-Chairman Stith, and I'm not saying that that's necessarily the perfect way to do it, but you have a situation where I wish the presiding officer was not a political office, right? Wouldn't it be nice if the presiding officer just represented the entire chamber? We all know that's not the case, right? We've been in the legislature collectively long enough to understand that that's not the case. The interest that I was trying to assert was actually what Representative Stith laid out, which is that it is up to exactly one person to decide whether political theater needs to take place or not. And while that one person most of the time might be a great person, there's nothing that indicates that that person is not inclined to political theater from time to time. And the idea that the process of political theater is in the hands of one individual rather than three, for example, in some way, whatever that process might be, is probably either helping to move forward political theater or potentially quench legitimate complaints depending on their specific political interests. Putting dismissal in the hand of one individual that is a political individual is not the best process, is what I'm getting at, Representative. I don't know what the right answer is. I'm just saying that there's a flaw there.
Thank you, Senator Rothfuss. Okay, so Director, you heard the list of the co-chairmen. Was there anything that you would like to add?
No, I think Co-Chairman Stith accurately reflected what I understand the direction to LSO to be at this point in time. So
I would concur with Senator Rothfuss on the co-chairman concerning that conflict provision as well, just for clarity on that. And then let's just put a consideration point to come back to this concern of Senator Rothfuss about the presiding officer versus a team of three. So we'll come back to that for our next meeting. With that, any final comments, Director, committee? Co-chairman Stith, you're going to make it. All right. Thank you so much for your hard work. I think we've made some progress. Appreciate your time. Our next meeting will also, as you know, be on Zoom. I think we talked about this. There's no need to do a full day hearing in some location, but rather we'll try to tackle this in 2 to 3 hour online meetings in order to move this through. So thank you for your time and attention today, and look forward to seeing you next time on Zoom. Director, thank you for all your hard work.
You bet.
Meeting adjourned.
Good to see you all. Take care. Bye.